All right, we're going to go ahead and get started. I'm just going to introduce our speakers today. So today's speaker for our webinar on Notice to Contractors, Lien and Bond Claim is Ariella Wagner. Ariella is the founder of Sunray Construction Solutions, which is a national construction document service that helps thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Sunray secures over $10 billion annually, and Ariella assists companies in developing business processes to secure their lien and bond claim rights. Ariella studied at the University of Nevada, Reno for her undergrad, where she studied political science and international affairs. She then went on to study Eastern European economics at the University of Oxford, and then received her MBA in international business from Nova Southeastern University. Alongside her today is Mark Cobb, who is attorney and founding partner of Cobb Law Group. Ladies and gentlemen, I would like to welcome our speakers, Ariella Wagner and Mark Cobb.
Thank you, Neil. This is Mark Cobb. I'm going to jump in for just a second. Neil gave a great introduction, and I'm so grateful for everybody who's attending this seminar. I just wanted to throw out super quickly how highly I think of Ariella Wagner. She and I have known each other, gosh, can't remember how long, but it's been 5, 6, 7, 8 years, maybe longer, that we've worked together. She's just remarkably knowledgeable. Talk about diligence and follow through. She's just someone I couldn't recommend higher. And so for these little lunch and learns, the series that we've started doing once a month, she was one of the first people we wanted to have speak. So without any further ado, Ariella, I'm about you to share your information with us.
One quick thing. So on this presentation, we'll be fielding questions. Hopefully you'll be able to find the questions section. Go ahead and type questions as you have them during the presentation. We'll be answering them at the end.
Well, thank you so much for that wonderful and warm introduction. I am definitely honored to be here today, and I hope that your 45-minute to hour lunch break is well worth it. So we will definitely get started. So little disclaimer, this is just, we're a webinar. It's not considered legal advice. When you do ask your questions, please kindly do not put any names of companies, and we'll get started with our agenda. So today we are going to discuss notice of commencements, notice to contractors, lien waivers, preliminary notice of lien rights, claims of liens, payment bond claims, and then we will take the time to answer any questions that you may have. And as Neil expressed, if you look on your right side of your screen with the Go to Webinar, there's an area. If you do have any questions, just please feel free to put all of those questions there, and we will answer them all at the end of the webinar. So let's get into notice of commencements. A notice of commencement, otherwise known to many people as a NOC, is a recorded document that is filed by the general contractor or the owner, and it's recorded in the county where the project is located. It lists all of the required recipients that are to receive a notice to contractor. So what is this notice of commencement all about? A little bit of a history lesson here. So before the notice of commencement was put into the statute, general contractors and owners would be surprised to find that there were subs and sub-subs and subs to suppliers, basically anyone that was on the project that was working, and there would be liens on the project. So the statute now has this non-requirement, which we'll get into in a moment, of a notice of commencement. So what has to be on the notice of commencement? So the prime contractor, of course, is on the notice of commencement. Location of where the project is being constructed. So the name of the project, the address, the legal description of the property, the owner of the property, if a surety exists or if a lender exists, and a general description of what you're doing to improve that project. So what is the time frame to record a notice of commencement? You have 15 days, of course, if you're a prime contractor, from the start of the work to file your notice of commencement. One of the things that Sunray can assist you with, you ever have an issue, we can help you with recording your notice of commencement. So technically, who is responsible for recording these? So technically the owner is responsible. However, the GC should be preparing and recording the notice of commencements. Now, what I find so interesting about Georgia and the notice of commencements, especially from the history of why notice of commencements even started, is a notice of a commencement even required? And interestingly enough, there is no requirement to record a notice of commencement. However, filing a notice of commencement at the start of each project is a very good idea, because if it's properly used, it could limit or even prevent claims of liens being filed or payment bond claims being made against your project for non-payment. And there are some very easy, useful steps to file the notice of commencements that you can take advantage to better take advantage of the laws. Specifically for general contractors, this can be monumental for you. If you record your notice of commencement timely and you have third-tier subs on the project, they will be able, excuse me, that was like a beep, we got that out then. If there are third-tier subs on the project, then they're required to send a notice to contractor. And here's the interesting thing. Again, there's no penalty for not filing a notice of commencement. So there's no preliminary notice requirement for third-tier subs to perfect their lien rights. So let's talk about the notice to contractor. But we're going to discuss a few important pieces before we get into the notice of contractor. We're going to learn the differences between private projects, public projects, and federal projects. So what is a private project? It's important to start off even right before you're working on your projects with your getting your information, project information sheets filled out accurately. So the first question you ask is, am I working on a residential, commercial, and then we'll talk about public in a moment, project. So you have, for private projects, you have the ability to lien them if you follow specific criteria. So it's important to know whether this project is an office building, a condo, a bank, warehouses. Those are just examples of private projects. If it's a public project, on the other hand, and this is why it's so important to know the difference of whether you're working on a private or a public project, because with public projects, lien rights do not apply to state-owned properties. State governments won't allow anyone to foreclose on its land because of sovereign immunity. It's quite logical. If you're working on a public school and you're installing windows, for example, the government isn't going to allow you to lien the property, then foreclose on the property, and then own the property. So that's why we have bonds for public projects. But we're going to speak of very specific ones. This is for state, city, county projects. That's very different. That's the Georgia Little Miller Act notice. So for those projects, construction bonds are secured by a surety payment, and any government project that is not federal in Georgia requires a bond if the project is over $100,000. So if you're working on a public project that's not federal, one of the questions you want to ask is my project bonded? Not all projects are bonded. So if your project is not bonded, what do? You want to maybe ask for a joint check agreement. And that would be one of the pro tips for your public jobs. So let's move on to our federal projects. So federal projects are anything owned by your federal government. And again, you can't lien federal property. Those are your naval bases, VA hospitals, courthouses, post offices. And there is no preliminary notice requirement for federal projects. So all jobs over $100,000 are required to carry a bond. There's no notice to contract requirements No preliminary notice requirements. However, best business practices is to send a preliminary notice at the beginning of the project, especially if you are a sub or a supplier to a sub. And if you are not paid, you have 90 days from last furnishing to send a Miller Act notice. It's a very important part of this is that third tier and higher have Miller Act rights. So you do want to know where you are on the food chain of payment there. So let's talk about the notice to contractor and why it is so important. So the owner pays the GC, but the GC does not pay you. This is a scenario that happens all the time. Owner does not pay the GC, who then cannot pay you. And the person who hires you claims that they are a tenant, but they're claims that they are the owner, but they're actually the tenant of the property. Another really great reason to send your notice to contractors is it lets your customers know that you're serious about getting paid on your terms, not their terms. And most importantly, it informs all the parties that you are working on the project. So what is a notice to contractor? I kind of think that it's a misnomer and really should possibly be called a preliminary notice. It goes to the contractor. The actual statutory form does go to the contractor, it goes to the owner, and then it goes to anyone that may be listed on the notice of commencement if one, of course, is recorded. And when does this notice to contractor need to be sent? The notice needs to be sent 30 days from first furnishing labor and or materials to the project. Now, that does not mean that it gets sent by first class, and it cannot be emailed and it cannot be faxed. It must be sent by certified mail. And the best business practice is once you have an agreement, whether that agreement is written or oral, you should be sending your notice to contractors immediately. Now, who is required to send a notice to contractor? So this is very fascinating because many people think, oh, even if I'm hired by the general contractor, I'm required to send the notice to contractor who work out of the state of Georgia. And actually, that's not the case. So if you are a third tier supplier or subcontractor and a notice of commencement was recorded and you wish to secure your lien or bond claim rights, you must send a notice to contractor. Again, as previously stated, you only have 30 days from first furnishing labor or material to send your notice to owner. So if you are a subcontractor or supplier hired directly by the general contractor, again, you're not required to send a notice to contractor. So who is required to send a notice to contractor? First tier subcontractors and suppliers, no notice requirements. The second tier here, subcontractors and suppliers and below. So if you are a sub, or we could really look at the third one here where it says tier 3. The two red circles, these are the sub-subs and the sub-sub to a supplier. They're going to be required to send a notice to contractor. So here's the pro tip on this. Even if you are hired directly by the general contractor, it's best business practices to send a notice to contractor. And a pro tip 2 is put a monetary threshold in your office and send notices on all jobs over a certain dollar amount. So maybe $2,500 or more, you want to send notice to contractors on. So this is a project information sheet with a QR code. So all you have to do is put your camera right onto that QR code. This is a really helpful tool for your office, for your credit and collections department. You could give this to your sales representatives, your branch managers, your dispatchers. And the purpose of this project information sheet is to gather all of the correct information at the beginning of the project. So for example, we just went over, is this a private project or is it a public project? If it is a public project, are we working on a project that's bonded? Or is it a federal project or a federal project? But if it's a public project, that's not bonded, what action do we want to take? And as we discussed before, perhaps a joint check agreement, the job site information, who the prime is, the bill to customer, etc. So if you want to take, I'll take one more second and then I'm going to go on to the next slide. So you could download that form for your office. Okay, I'm going to go on to the next slide. Now, lien waivers in Georgia. I like thinking of lien waivers as a receipt for payment. The name of the title can be really, really confusing. And there's two types of waivers. There's the waiver and release of lien and payment bond rights upon interim payment. And then, of course, there's the waiver and release of lien and payment bond rights upon final payment. Now, Georgia lien waivers are very, I want to say, tricky. So on the bottom of the waivers in bold and caps, there is language that you must be aware of. So if there's anything that I want to make sure that everyone on this webinar learns is the waivers, the lien waivers and the language at the bottom of the page. So even after this webinar, I suggest that everyone listening should print out these waivers and read it out loud. Many people just sign documents because by our very nature, we are trusting, but it's important to read the language. And here's why it's so important. With lien waivers, if you do not receive payment within 90 days, you will lose your lien rights if you do not record an affidavit of non-payment. So this interim payment and final payment, if you are not paid, there is language. Georgia lien waivers are tricky because they're conditional for 90 days, but then they become unconditional 90 days after they are signed if the payment has not been received or the signatory will lose its lien rights. So you want to be very careful. The 90-day deadline date runs from the date of the lien waiver. It has nothing to do with the last day of work. The 90 days begins running even if you continue working on the project. So again, it's very important that to note that the 90 days runs from the date of the lien waiver and not the last day of work. And the best business practice is to mark your calendars. And if you are not paid within 30 days, proceed forward with a notice of, an affidavit of non-payment. So again, caution, if you're not paid, you must take another action. It's not just an affidavit of non-payment is not just a document that you just sign and you send off. It's an actual document that must be recorded in the county. So make sure, here's your pro tip, make sure you have an internal process that monitors the payment being received. In addition, do not just let anyone in your office sign these releases. There should be a very strict approval process. If you do not receive payment within 30 days, and you may want to start thinking about filing your affidavit of non-payment. And as a friendly reminder, this recording may take an extra 10 to 15 days because the recorder's offices do not always run on time. So, preliminary notice of lien rights. This is another document that's used. This is not a notice to contractor. This is not a lien. This is another tool used in Georgia to secure your money. You only have 30 days from first furnishing labor and material to the project to record your preliminary lien notice, and any general contractor, supplier is recommended for big ticket items or possible credit issues that someone may have to utilize the preliminary notice of lien rights. And this document is recorded in the county. So claims of liens. So a claim of lien is one of the most powerful collection tools in the construction industry. A lien clouds the title of the property. If there's a lender funding the project, the lender can stop funding to make sure that all debts are paid. We have seen multi-million-dollar projects come to a halt because funding stopped. So it's pretty powerful. It can force the sale of a property to pay for debt owed to you. And this is very important. And this is another one that I'd put a star by. Attorney's fees. When you start your projects, and for your larger projects, you really want to make sure that you have a written contract in place with an attorney's fee provision. So I highly recommend that you speak with Mark Cobb to review your contracts and add that attorney's fee provision, because you don't automatically get attorney's fees in Georgia. You have 90 days from the last day you're on the property to lien your property. Now, that doesn't mean you give your customer until the 90th day. Many people think that it's an instantaneously click of the button. Remember, as I said before about the affidavits of non-payment and recording, it may take up to 15 days or more for the recorder's office to record their liens. So the best business practices is really at day 60, you're sending a demand letter. You're very aggressive with your payment. And then if you don't hear anything by the 70th day, you want to think about liening that project. Now, one other little detail that's important to look out for is the deadline to mail your lien. So there's a very short deadline. A copy of the lien must be mailed within two business days of filing the lien. So just beware of that deadline. And how about your foreclosure on the lien? Now, you have 365 days from recording of the lien to foreclose on the property. And then it's forever lost. There's no such thing as I can re-record my lien. So if you aren't paid 60 days from when that lien was recorded, you may want to think about reaching out to the Cobb Law Firm and moving forward with the foreclosure process. So certainly do not wait until the last minute to foreclose either. So let's talk about our payment bond claims. Now, this is specific to our public projects, such as anything that's not actually federal. So a bond is seeking payment against a bond versus a lien, which is a claim against the property. So a lot of people, as I discussed maybe 15 minutes ago, when you're thinking, I want you to have totally two separate columns in your brain. So a bond claim versus the lien claim. A bond, again, you're going after payment for, if you're going after the payment, you're going after a surety. You're not going after the property, okay? If you're not contracted directly by the contractor, you must send a notice to contractor within 30 days from first furnishing to secure your bond claim rights. And you have 90 days from last furnishing labor materials to claim against the bond. And again, we're going back to our waivers and releases. You want to be very, very, very careful on when you've signed them and making sure that you actually have received payment, because the same rules apply with your payment bonds. Okay, so putting it all together. Within 15 days from the start of the project, you will record your notice of commencements if you are the prime contractor. Within 30 days of your first work, you want to send your notice to contractors. Within 90 days of your last work, record a lien or serve your claim against the bonds. And then we're going to make sure that you have an attorney's fee provision in your contract for your legal fees. And then you have file your suit on the lien foreclosure within 365 days from the recording date of the lien. And the final piece of your bond claims, you have 6 months to 1 year from your date of your last work. It really depends on your bond, the type of bond you have when you're going to file suit against the bond. Just a little bit about Sunray. We have a pretty extraordinary online system. This is just an image of our application. It will tell you your next action item if you put in your last day on the job. It calculates everything for you very easily so you know what your next steps are. You can track all of your orders online, view your completed signatures from the United States Postal Service to make sure that the parties who are required to receive them receive them. We have a very robust system. We have an application interface with some of our customers, and that's just a fancy way of just basically saying it's a bridge from your system, our system to your system. It connects the two data points so that there's no data entry. And for those who don't have a IT department, you can actually upload all of your orders using an Excel spreadsheet. We also offer e-recording if you need any assistance with e-recording, and that is it. So with that, are there any questions on this little refresher of notice of commencements, notice of contractors, and all the other documents?
All right, so we have a couple of questions here. Let's start. Mike Pitt is asking, or he says, hi, we are an equipment rental company, in parentheses, construction, hoists, and mast climbing platforms. Are we treated differently to a subcontractor working on a site? So
you are an equipment lessor and you are hired by a subcontractor, is that correct? Is that as I'm understanding the question?
I believe so.
Okay, so in order to secure your lien rights, you want to make sure that you send a notice to contractor if, of course, there is a notice of commencement recorded.
Okay. Mike Pitt says yes and no to your question.
Okay, no problem. So imagine, go ahead.
So the next question is by Mr. Flores. He asks, is it legal for the general contractor to have listed the wrong surety / bond company on the notice of commencement?
You know, I am going to have Mark answer that question, but if it's done with some type of willful intent to, harm the subs, I imagine that that's 100% illegal. If it's an error, then I'd really like Mark to answer that one.
No, you raised a great point, Ariella. So you're exactly right. There's a gray area. There's no absolute case in Georgia that addresses that issue. However, it's an overriding theme that the point of the notice of commencement is to provide information to those downstream where they can look for their money. And so I think that if it was either accidental or intentional, it probably voids the whole notice of commencement. Therefore, it could void your right to have to have sent a notice to owner and notice to contractor. If they had a surety and the surety changed midstream, or if it was more of a typographical error, I can't imagine surety, missing that typographical error, it might not invalidate the notice of commencement. So each situation is going to be based upon facts and just has to be analyzed.
Are there any other questions? Because those seem to be the only two that have been asked. I'm going to give a couple more minutes just in case.
Well, I think Ariella, I must say, I told you at the beginning, I'd worked with her for years and I knew she was smart, but having heard her explain a relatively complex, very nuanced scheme involving Georgia, I thought you did a fantastic job of making it clear, concise, and really exactly what we're looking for these lunch and learns. So thank you very much, Ariella. I appreciate it.
Well, I thank you very much, and I'm truly honored to be on this webinar with you. And if anyone does have a question, obviously our information is on the screen. I am happy to answer any questions that you may have. Sometimes, you go, oh, goodness gracious, I actually do have this question, and you forget, or you might even be nervous. I could promise everyone on this call, when I first started doing these webinars, I would shake like a leaf. So I can't even imagine if you have a question, you might be nervous. And the gentleman that did ask, that said yes and no, If you would be so kind to elaborate, shoot us an email so that we can make sure your question was answered.
We got a couple more questions in here.
Okay.
So Demetria Patton asks, if we are the only subcontractor, do you only file an NTC when they file a notice?
If you are the only subcontractor, so are they working? It really matters where you are on the food chain. So if you are a sub hired directly by the general contractor, you are not required to send a notice to contractor. Full stop. It's kind of wonderful, but but not in a way. And the not is, I think it's really fabulous for the owner of the property to receive a notice to contractor, but I did not write the statute, and probably no one really cares about my opinion. But to answer that again, if you're the only sub and you're working for the GC, no notice to contractor requirement. I want to make sure that I address your question, ma'am.
She says hired by the general contractor.
Okay, great.
She said that you did
Okay.
answer the question.
Very good, thank you.
And then Mike Pitt asks, does your software cover all states in the Southeast?
Yes, it does. We are a national software company.
That seems to be the last of the questions. All right.
Yeah, so this is Mark again to reiterate what Ariel said. If any questions, send them directly to her, send them to me. I have just seen an email come in requesting copies of the PowerPoint. We can distribute those. Contact Neil, or if you Ariel or me, we will forward it to Neil to get those to you. This has been recorded and it will go up on our website. It usually takes about a week to get up on the website, but if you wanted to repeat this for a different group in your office, you're welcome to do so. It'll be on the coblawgroup.net website. Ariel, I don't know if you post videos or not, but if you do, you're certainly welcome to a copy of it as well.
Thank you. Well, thank you all for attending the Lunch and Learn. I hope you had a lovely lunch, and I wish everyone a sunny day.